We are back on the record in the case of State versus Joseph Ferlazzo Jr., 21 CR 8967. All parties are present after a lunch break, and I think we're ready for argument. Is that correct?
That's correct, Judge.
Ms. George.
Thank you. Judge, the state's request in this case is that Mr. Ferlazzo be sentenced to 50 years to life to serve. The gravity of this request did not come lightly, and to justify this request, the state wants to first just highlight briefly the case facts as outlined at trial. In October of 2021, Mr. Ferlazzo came to Vermont with his then wife to celebrate their one-year anniversary and to see his sister Nicole. He was 41 years old at the time, Emily was 22. An argument eventually ensues between the two of them, and Emily is very clear that she wants to leave, that she no longer wants to be with him, and she goes to bed. And rather than either let her leave or to leave himself to give her space, he sat on the couch and he stewed. He ultimately got up, he walked to the closet, he retrieved a handgun equipped with a silencer, he grabbed a throw pillow from the couch, he jumped on top of her, he pinned her down on the bed, put the throw pillow over her head, over her face, and shot her not once but twice in the head, killing her. Rather than call for help, rather than go right outside and get his sister to call the police, he put a plastic grocery bag over her head. He tied a trash bag around her neck so that she didn't get blood in the camper. He moved her body to the shower. He put her shoes, her glasses, her phone in a bag to throw out. He bagged up the bloody pillows and the bloody bedding, put new pillows and new bedding on the bed, flipped the mattress, put those new beddings out, and went to bed. The next morning, he makes French press coffee for he and his sister. He takes a shower in her condo, and he goes to eat breakfast with his sister and her boyfriend. He has an omelet, and he drinks one mimosa. Then he goes to his best friend's house in St. Albans, Sarah and Jason Lang. He tells them that Emily left while she's actually laying dead in his van in their driveway. Later that day, he tattoos his sister. Then he goes to dinner with her and her boyfriend. He doesn't tell them anything about what he did. And he told the jury that he didn't tell them because he didn't want to bring his drama into their life, because he considered murdering his wife drama. The next day, he meets his sister in Burlington, again for breakfast, coffee, and to hang around Church Street. He stops at Hannaford on his way home, or back to the Langs, to get bleach. And he goes back to the van to, quote, clean up his mess. He hangs out at a bonfire with friends and an off-duty police officer, never says anything about what he's done or about his wife being in the van. In fact, he says so little about Emily in the over 5 hours that he's hanging out at this bonfire that the officer didn't even know he was married. And at some point, between all of these activities, he stabs Emily's body 18 times. He dismembers her body into pieces, including sawing off her head, and he puts her body in trash bags like she's garbage. By Monday, he realizes that he needs to get rid of her body, and that at some point, people are going to start looking for Emily. So he goes back to his in-laws in New Hampshire in order to get his Jeep. And rather than tell them to take responsibility for what he's done or to give them some peace of mind about where their daughter is, he lies to them. He takes a shower in their shower. He eats a big bowl of spaghetti made by his father-in-law. He gives them her ID. He lies to the police about where his camper is. And he leaves in his Jeep headed back to Vermont. He arrives at another friend's house around 11 p.m. He knows at this point that the police are onto him. He knows he needs to get the van and get rid of Emily's body. But he sees the police at the Langs, knows they will be finding Emily. He tells Spencer he killed Emily and that she's in the van, and he gets out of the car and flees. The next day, he's taken into custody and he's interviewed by police. This interview, from the state's perspective, is the one time throughout all of this, up to and including today, that Mr. Ferlazzo appears to be honest about what happened in the van. He quickly takes responsibility, I believe within 1 minute, telling the police what he did. And although he shows little to no remorse, he does give a detailed explanation about what happened, never once saying anything about self-defense or Emily having a gun. He's arrested shortly after. He's arraigned on first-degree murder. And when multiple opportunities to make this process easier for Emily's family, he does the opposite, as outlined in the statements from Adrian and David in the PSI. For example, as it's been noted, he immediately fights Emily's parents in court to keep their shared dog from going to Emily's family. In the defense sentencing memorandum, defense takes issue with this statement claiming that the dog was his and not their shared dog, which is telling from the state's perspective, as though him getting the dog just months before they met completely negates the fact that they were married and cared for this dog together. Such a spiteful and vindictive stance to take in the months and now years after committing this horrific offense against their daughter. Also of importance from the state's perspective and highlighted in the PSI is that less than 2 weeks after murdering, stabbing, and dismembering his wife, who he claimed to be the love of his life, and after being arraigned on a first-degree murder charge, he receives a major disciplinary report while incarcerated for hitting on a female correctional officer, specifically by propositioning her, calling her pumpkin, and asking for her phone number. Next, he doesn't accept responsibility for his actions and tries to have his clearly voluntary confession thrown out. This request, from the state's perspective, was without merit. It delayed justice for Emily, dragged her family through litigation, and he even had the audacity at the suppression hearing to act like the signature on the Miranda waiver wasn't his, despite video evidence that he signed it and that he was coherent and lucid when he did so. He further attempted to convince this court that he hadn't eaten or slept for days, despite overwhelming evidence that in the days before he spoke to the police, he had had breakfast with his sister at Maxie's, he'd had dinner with his sister at Twig's, he'd had breakfast again with his sister at Henry's, and just the night before his interview, he'd eaten spaghetti at his in-laws. He had repeatedly attempted to convince this court that Vermont State Police had treated him poorly, that they had ignored his pleas for help, ignored his pleas for sleep and food, and then attempted to convince the court that they treated him so well that he was unable to make a voluntary confession. As the court has now seen, Mr. Ferlazzo was treated with the utmost respect during this interview and gave a very thorough and mostly complete voluntary statement. And then we go to trial. The state, as this court knows, does not engage in trial penalties when individuals choose to assert their constitutional right to a trial by jury. That right is a foundation of our legal system that the state has the greatest respect for. But that right, and the state's respect for that right, extends to Mr. Ferlazzo's ability to make the state prove their case and to assert a defense. It does not extend to Mr. Ferlazzo's ability to get on the witness stand and do what he did. What he did on the witness stand from the state's perspective is appalling, and the state considers it an incredibly aggravating factor in this case. From the moment that he started testifying, he started degrading Emily. From stating that the moment he met her, he told his friends he wanted to make her his next ex-wife, to smirking on the stand after saying they were all hanging out and chopping it up, to describing there being in a polyamorous relationship, but what he was actually describing was a relationship in which he was unfaithful repeatedly to Emily and seemingly blaming her for not being okay with him having sex with other women and not understanding or appreciating his sexual needs. He took no responsibility, he took no accountability, and he deflected all blame to Emily. He repeated statements about how Emily was abusive, both physically and emotionally, and they were yet another attempt to deflect any blame and to sully Emily's memory, and they were not corroborated by a single piece of evidence. His new version at trial about how he ended up killing Emily was a lie. And we know it was a lie because it was contrary to all of the physical and forensic evidence presented. For example, he repeatedly stated that he held her body and that her body dropped back to the pillow. That is a lie. We know it was a lie because the medical examiner clearly testified that Emily's head was against her pillow when she was shot, and that he placed a throw pillow over her face and shot her in the head with a silencer. He said they had both been drinking. That is a lie. The toxicology report showed that Emily had no alcohol in her system. He said they both slept with guns under their pillows, but her mother, Adrian, testified that Emily did not carry a gun. Detective Voris testified that all the firearms were purchased by Joseph, and the only gun found under any pillow when the van was searched was the gun used to kill Emily. On cross, he even repeatedly denied putting a garbage bag over Emily's head or tying one around her neck, despite knowing that photos of exactly this exist, which were taken during Emily's autopsy. The state believed at the time that Mr. Ferlazzo opened the door for the state to present those photos, but decided not to, mostly for Emily's family. But it is important for the court to know. These are just a few of the lies that Mr. Ferlazzo told while on the stand, all in an effort to degrade Emily, blame Emily, and make himself the victim. The state was frankly shocked to read in the sentencing memorandum that Mr. Ferlazzo went out of his way to disagree with much of Adrian's victim impact statement, as if even at this moment in time, after being convicted, he still doesn't believe that she has a right to provide a statement that he possibly could disagree with. But most notably, he went out of his way to disagree with her statement that he lied in his testimony and that the court should disregard her statement because he has a constitutional right to assert a self-defense claim. The state would say again that that right to assert a defense is a constitutional right. The right to commit perjury is absolutely not. And as the court noted in its order denying Mr. Ferlazzo a new trial, Mr. Ferlazzo's trial version of events leading up to Emily's murder is inconsistent with the physical evidence produced at trial, and the jury was well within its right to discredit any of Mr. Ferlazzo's testimony or statements that were not independently corroborated, including any testimony relevant to alleged provocation. And they did exactly that. The jury rejected Mr. Ferlazzo's version of events, and the court must consider that in sentencing. To get on the stand and claim amnesia as to almost every incident that occurred after Emily's murder, including the stabbing of her body, the dismemberment, the breakfast, the visits, the bonfire, the tattoo, the text he sent, pretending that she was still alive, and to only remember that he was holding her and mourning her with the dog, is in the state's opinion a very aggravating factor. And the state believes what they heard Dr. Powell testify is that his amnesia is not credible. Then judge, he's found guilty of first-degree murder. The state has proven their case. He's set to be sentenced, and does he take accountability then? No. He instead tries to fire his attorneys because they aren't doing what he tells them to. And instead of just refraining from not making a statement for the PSI, he decides instead to provide a 9-sentence statement that continues to blame Emily, continues to take no accountability, says she was angry, that they were both drinking, says on one hand that he made a split-second decision that he had to kill her, but also said that if he hadn't been drinking or doing drugs, he probably would have made a different decision. No accountability, all excuses and deflection of blame. Under the statute, the court has to consider a number of factors when determining a just sentence. First, the nature and circumstances of the crime. This is, of course, the most aggravating factor here. The nature and circumstances of this crime are horrific, incredibly violent, unprovoked, and unjustified. The post-mortem acts are evidence that Mr. Ferlazzo was motivated by rage and anger, and are evidence of his desire to hide his actions and not be held responsible. The history and character of the defendant. The only mitigating factor from the state's perspective is that Mr. Ferlazzo lacks any criminal convictions. But he doesn't lack bad character. He admitted to having affairs on his wife, He characterized it as polyamory. He refused to let his in-laws have the shared dog, made them go to court to get it. He murdered his wife and then blamed her, attempted to seduce a female correctional officer. These are not redeeming qualities. And the state would ask that the court read the reference letters provided by Mr. Ferlazzo in the lens of what we know about how Mr. Ferlazzo and Emily met and became involved. The state would also ask the court to read those letters provided in the lens of what Mr. Ferlazzo himself testified to at trial regarding his relationships with his clients that Emily took issue with. In fact, he testified that Emily called Mr. Ferlazzo out for his inappropriate and unprofessional relationships with clients. And I believe Mr. Ferlazzo even testified that he would have relationships with his clients at the office that he did tattoos for, and that Emily would get upset with him and threaten to have his license revoked. Mr. Ferlazzo and Emily met through piercing and tattooing. She was 20, he was 39 or 40. She was struggling with trauma related to a sexual assault and some family dynamics. He made her feel seen, loved, and safe, until, of course, he didn't. Ms. Trombley, one of the letters, was 13 years old when she met Mr. Ferlazzo, who was then 33 or 34. She met him through piercing and tattooing. She described spending time with him both when she was a client and on a personal level. She was a vulnerable young girl struggling with an eating disorder and abusive relationships, and he was 20 years older than her. Ms. Dober, who was 21 when she met Mr. Ferlazzo, he was 36 or 37, said that when he gave her a tattoo, they started communicating and spending more time together outside of the tattoo shop. And she described the murder of Emily as a slip in judgment. Another young woman, Ms. Lefebvre, had met Mr. Ferlazzo around 2016 when she walked into the tattoo shop and they started hanging out, having dinner, watching movies, went to the Boston Aquarium. He taught her how to swim, going to the beach, having dinners together. Defense wants this court to read those statements as proof that he is of high moral character, but that is not the way the state reads them. I think they show us exactly who Mr. Ferlazzo is. He's a man that finds young women, young vulnerable women, while tattooing and piercing them and begins inappropriate and unprofessional relationships with them. He also submitted letters from his former cellmate, Nicholas Mora, who ironically has 2 prior convictions for domestic assault. Lastly, Judge, the state asks that this court consider the letter from Sarah and Jason Lang and give them the weight that it deserves. The Langs claim that Joseph is like a brother to them, but the most they really could say was that they miss him. The court asked the state to consider that Mr. Ferlazzo trusted these 2 enough that he brought his van to their house and left it with Emily's body inside. He told investigators during his interview that when he told the Langs his lie that they had fought and she had left him, that their response was good fucking riddance. These are the same 2 that refused to give Remington, now named Callie, back to the Basses after they found out what Mr. Ferlazzo had done to her. Third, Judge, the defendant's family circumstances and relationships. The state is not aware of any lasting family relationships that Mr. Ferlazzo has. He appears to have been estranged from his family before he murdered Emily, and certainly even more now, further evidenced by Dr. Powell's testimony that none would respond to him. The state is unaware of any relationship he has with his father. The state knows that his stepmother was stabbed to death, a murder which remains unsolved. And he was working on rekindling his relationship with his sister, Nicole, until the weekend in question, in which he seemingly went out of his way to involve his sister in the aftermath of Emily's murder. As the court saw in Nicole's testimony, this incident has caused her incredible trauma and anxiety, knowing that her brother committed this murder and then spent the entire weekend with her, including tattooing her arm, lying to her repeatedly, and the fact that she had no idea has significantly impacted her ability to trust people. Her arm, with the large tattoo now on it, is a constant reminder for her about what her brother did and how close he brought her to it. The fact that Mr. Ferlazzo refused to accept responsibility and went to trial put his sister in a particularly tough and difficult trial, one live streamed for the world to watch and has only further estranged the two of them. The court further saw how this impacted his friend Spencer, whom also believed him to be a brother. His attempt to make him an accomplice after this has significantly impacted him. The state would also like the court to consider that no one has credibly testified that Mr. Ferlazzo was abused as a child. The court has not heard any evidence of this other than the representation from defense counsel in their sentencing memo. In fact, during Mr. Ferlazzo's testimony and her deposition, defense repeatedly tried to get this information from her, and she denied any abuse in their household as children. The impact on minor children, thankfully, is not applicable. And the need for treatment, Judge. The state doesn't know what Mr. Ferlazzo needs for treatment. While he has stated at trial and since that he murdered Emily in self-defense and that he had to do it, he is also now blaming drugs and alcohol, but there's no evidence that he had or has a significant drug or alcohol issue. In fact, I would remind this court that the off-duty officer who spent over 5 hours with him the day after the murder noted that he was not abusing marijuana, he was using it but not abusing it, and that he wasn't drinking at all. His sister didn't know any drug or alcohol use of concern. He had one mimosa at breakfast. When speaking with police, he didn't indicate any extreme drug or alcohol use and had a very clear memory of what occurred. This new claim of drugs and alcohol being to blame is just another way for Mr. Ferlazzo to deflect blame from himself. If he were in the throes of alcoholism or drug abuse, all of the people that interacted with him that weekend, and it was many, would have noted some level of problem. And there's no evidence of this. This is not a case about alcohol use or drug use. It is a case about rage, violence, control, abuse, and lies. There is zero evidence to support that drugs or alcohol played any role in what Mr. Ferlazzo did to Emily. As to any noncompliance with court orders or failures to appear, of course, Mr. Ferlazzo has been incarcerated since this incident, but the state would note that the evidence is clear that he did repeatedly lie to try to get out of this case while making plans to hide Emily's body. The risk to self, other, and community at large presented by the defendant, Judge, the state would submit that there is no greater risk to the public, specifically the women in our community, than a man who is unfaithful to his 22-year-old wife, blames her for not allowing him to be unfaithful, scares her, intimidates her, and then murders her when she tells him she doesn't want to be with him anymore, stabs her body 18 times, including through her heart, goes about his weekend with friends and family as if he's completely unfazed, dismembers her body, puts her in trash bags, and then blames her for the entire thing. There is no greater risk than a man who refuses to accept responsibility and thinking that believing because he admitted to killing her is the same thing as taking responsibility. This is not an acceptance of responsibility, and simply saying that he did it is not the same thing. The state would remind the court that days after murdering Emily, knowing full well where she is, he sent her a text message stating, "You're an asshole. I don't deserve this shit." Mr. Ferlazzo appears to believe that every woman that he engages with owes him everything, including their life, and is owed nothing in return. This type of ego and the risk it poses to his next potential partner cannot be overstated. When thinking about comparable cases, Judge, in Vermont, I struggled to find a case that adequately compares to this one. The premeditation, calculation, postmortem dismemberment, postmortem behavior, lying at trial, continuing to lie for the PSI, tearing apart the victim impact statement in a sentencing memorandum, all feels incomparable. Again, had Mr. Ferlazzo simply made the state prove their case, the state would likely be asking for somewhere in the range of the mandatory minimum, or something close to that. But that is not what he did. got on the stand and made the very deliberate and unnecessary choice to lie and blame Emily for her own murder. To testify that she was assaultive not just towards him, but her beloved dog. The court saw how Emily interacted with Callie, Remington, now Callie, and the kittens, to think or to put forth that she might harm them from the state's perspective is an aggravating factor. He then doubled down on that statement, again, when he tore apart every sentence that Emily's family stated in their victim impact statement. He's gone to extreme lengths to discredit her, to blame her, to insult her memory, and to insult her family and friends. The complete detachment from any sense of self-recognition and accountability in the state's opinion should be met by this court with a greater punishment than the mandatory minimum. The closest comparator in recent history the state could think of is Aida Garung, in which court is well aware of the extreme circumstances in that case. And even in that case, after trial, in which Mr. Garung did not testify, the court sentenced him to the mandatory minimum of 35 years.
I did not, no.
Oh,
It was a split to serve,
27.
a lower amount.
The state believes the case is significantly more aggravating and deserves a significantly higher sentence. And the state's only briefly, Judge, going to address Mr. Ferlazzo's request for a sentence to say that the state understands the position the defense needs to take, but this request of 15 years is an insult to Emily. It's an insult to her family and her friends, the Vermont State Police, the people of our community and state. 15 years, followed by probation for the premeditated murder of his wife, for jumping on top of her, pinning her down, putting a pillow over her face and shooting her twice, by stabbing her body after dismembering her, cutting her into pieces, putting her in garbage bags, and then going about his weekend, and then consistently lying about what happened at trial and since. Had Mr. Ferlazzo been found guilty of voluntary manslaughter, 15 years would be appropriate, but he was not, and so it is not, and the state believes that Mr. Ferlazzo should get 15 years on top of the mandatory minimum because of his behavior at the time and since. Finally, Judge, you heard from Emily's parents, David and Adrian, her brothers, her best friend Lauren. You haven't heard from countless others in the courtroom and the community who knew and loved Emily. Every single person that knew her, or even some that didn't, feel her loss deeply and immensely. Her smile, as the court saw, her incredible voice, her kindness, her love, and her contagious laugh. If they were all allowed to speak, they would. Her aunt and cousins wanted you to know that she is spunky, she was full of life, bright, driven, talented, dedicated, compassionate, and full of laughter. They want to know, the court to know that they are here for her and that they feel her loss every day. The state, Your Honor, is seeking a sentence of 50 years to life to account for Mr. Ferlazzo's actions at the time and since, and the risk he poses upon release. With good time, the state expects he would be eligible, he could be eligible after 40 years. Mr. Ferlazzo was nearly 42 at the time. Emily was 22. He had twice the number of years on this earth than she did when he killed her, and it seems reasonable he should spend the same number of years inside a jail that he had the opportunity to spend outside of it. Thank you.
Thank you. Thank you. Ms. Chance.
Thank you, Judge. I just have a few brief comments in response to the state's argument. And the first is to remind the court, which I'm sure the court is well aware of, that this is argument, not evidence. The state has made interpretations and made allegations about Mr. Ferlazzo.
I will say this, I'm only going to consider evidence that was introduced in this case and not things that may very well be true but are not part of the record.
That was my,
And
that's where I was going.
I'll further say that decisions counsel make to litigate certain issues pre-trial, I'm not going to consider that as a aggravating event either. There is a lot which the state has said that I am going to consider and have been considering, but
Thank you, Judge.
those things I will not.
Thank you. Those were some of the things I was going to raise in response to the state's argument. The state, one thing that I would like to raise, though, is the state has repeatedly referred to his testimony at trial as lying and has endorsed the perjury allegation. He has not been charged with perjury. This court, I'm asking to not consider perjury as...
So how would you have the court consider it if the court finds it entirely incredible, and I don't want to mince words, I do. How would you have the court interpreted?
So over the lunch break, I looked up 13 VSA 2901A, perjury by inconsistent statements. It has 3 prongs: that the person knowingly makes 2 or more statements under oath or affirmation which are material. That's the statement to the police and the statement at trial. And the statements were made within the period of statute of limitations. The one that I don't think there's evidence before the court is that the statements are inconsistent to the degree that the person necessarily believed one of them to be false. And I don't think there's evidence before the court that Mr. Ferlazzo...
So how do you interpret how he... I'm fascinated in this question. I wish Dr. Powell would have discussed it. I asked him just a few questions. He didn't think much of the amnesia post-clarity. But how do you interpret that he has a detailed memory of something vastly different, which is much more consistent with all of the evidence, and then over the course of a few years has amnesia for almost every event, except a different version now for what occurred?
So I certainly am not a psychologist. I'm just a lawyer. Neither is the state. And to ascribe his motives in the inconsistent statements to deliberate deception, I don't think anyone in this courtroom can do. He testified that he had been drinking constantly. He testified to that on the stand. And for a chronic alcoholic, my layperson's understanding is that they can be functional if they are, if I may, chronic alcoholics. So the fact that no one else may have noticed that he was constantly, continuously intoxicated over the course of the weekend is not surprising from a layperson's experience having been doing this job. His testimony was a few weeks after the event, he began having dreams about what happened and remembered more clearly than what he said to the police. Now, we have all seen the video, and he appears to be quite rational in the video. That's my explanation, because it's all that's what Mr. Ferlazzo testified to. He began to remember after the fact, after he talked to the police.
So would you agree with the court statement that either he's intentionally lying or he has done whatever he needs to do to psychologically be able to live with himself and has essentially reinvented a story?
So I can't agree with either of those, Judge, because his testimony was not to that effect.
Okay.
I'm not a psychologist.
Right. Good enough.
All I know is what he testified to. He remembered it. Whether that is a function of his having to live with his own actions, I'm not qualified to say. Okay. And I don't think the court is either.
Okay.
His testimony is what it is. But to ascribe it to being a deliberate lie, I don't think there's sufficient evidence before this court, which there has to be a preponderance of evidence in sentencing, and the burden is not on him about any facts that are alleged for the court to take them into consideration for sentencing.
Okay.
And I don't think there's any evidence before the court. There's speculation and assumption about his motivations, about the inconsistent statements. That's all. There's no evidence that he is deliberately lying, and I don't think the court can consider that. And I'm going to refer the court to State v. Blackmer, which is a 2025 case.
You have the site?
I'll give you the citation. 2025 WL 1009533. And in addition to repeating what the court already knows, that it has to be an individualized sentence based on the facts and the defendant's personality, that any uncharged conduct by the defendant must be disclosed sufficiently in advance of sentencing to allow an adequate opportunity for rebuttal. The court may take it into account only if it specifically finds each fact objected to, and we do object to the allegation that he was lying, has been shown to be reliable by a preponderance of the evidence. And it is not his obligation to disprove. So I don't think that the court, and I'm asking the court and would object if the court considers deliberate lying and AKA perjury in fashioning its sentence.
Okay.
So then let me go back. Yes, we asked for a split of 15 years, and I fully recognize that that may be considered wholly and unduly lenient given all the facts of this case. The justification is that voluntary manslaughter was one of the lesser included charges. The jury did not agree, and I respect the jury's decision without question, but I do think that his testimony about passion provocation was consistent both to in his statement to the police and his testimony. And because of that, I think there is some recognition and weight that the court can, not must, but can in its discretion give to his understanding and experience of what happened. So the voluntary manslaughter, as the court and the state know, maximum is 15 years. I think my expectation is that the court will find other factors that negate the request, but that's the basis of that request. And I included conditions of probation should the court decide on a split of whatever length. So that's our basis for the 15 years. As the court knows, and I know the state went through a list of factors, but the traditional factors the court must consider are punishment, specific deterrence, general deterrence, and rehabilitation. Incarceration is punishment. The duration of that incarceration is primarily what's before the court today. I posit that incarceration of any length is extremely difficult, and that people who are incarcerated, their lives are so different from being out in the community, even if they're under conditions of supervision. So the punishment portion of what the court has to consider is the length of incarceration that this deserves. As far as deterrence, general deterrence, the court and the state usually say, send a message to the community that this conduct will not. I am unaware of any statistic or documentation that this is effective in deterring other people from committing crimes. Specific deterrence is quite different. It takes this individual out of society so as not to harm anyone else. And that is a consideration for the court. Rehabilitation is the last of the traditional factors. Mr. Ferlazzo has indicated that he now knows that he has had substance abuse issues for years. He is willing to undergo treatment, both for mental health and for alcohol and drug use. There's no evidence before the court, primarily because of his lack of a criminal record, that he wouldn't comply with that an instruction from the court to undergo and continue for the rest of his life any kind of counseling. This is a man who reached 42 years old with no criminal record. I understand how the state is interpreting the letters of reference, but these are all people who experienced contact with him in a nonviolent and, in fact, supportive and gentle way. The fact of no criminal history is very important, and it indicates that he's able to conform his conduct with the requirements of law. It also indicates that there's no indication that he couldn't comply with future court orders. He developed his profession, and contrary to it being used to, as the state said, lure young women, he was a respected and well-known tattoo artist who earned a reasonable income from that profession. He certainly could go back to that profession if and when he's safely released back into society. There's a lot made of his victim bashing, and he's telling the court and the community what he remembers, his reality. There's nothing else he can do. He cannot, just because he's been convicted, now abandon his claim of self-defense and say, oh, okay, I just made it up. This is what's real for him. That's why he testified to it under oath.
But even if that's true, isn't that one of the things the state's pointing is so scary about the case? If he can create a reality for which things that aren't very real become real in his mind as justification for behavior, isn't that a problem?
No, because the court is assuming that his version is not true, and I'm not disputing the verdict. The jury has made a determination of what they believe is credible, but only he knows what actually happened. And for the court to decide that he's fantasizing or making it up, essentially just so he can live with himself, I don't think there's a basis for that. So to say that, is it a problem that he's essentially reinventing reality, I don't think there's any testimony or evidence that that's the case, other than the fact that the jury didn't.
I'll give you a couple of soft examples.
Sure.
He claimed, and it was all about this image, he claimed they arrived, I think, at 5:30 while it was still light. And he really requested Emily to go out for a walk with him. And it was still light out, and let's do that. And then but she didn't want to. And then again at sunset to do that. I think the uncontroverted evidence is they arrived at, I think, 7:19, well after sunset that night. It's just that, so there's an image he's created for himself one way or another that doesn't seem to be at all connected with what really happened.
Well, I understand the court's example, but frankly, not remembering what time of day.
It was a soft example, but
I hear you, Judge, and I appreciate that the court has that recollection. But that, to me, is such a qualitative difference from remembering the nature of the relationship and what happened that night and the following days that
Yeah.
lots of people forget what time they arrived somewhere.
Okay.
And I'm not persuaded that that's a factor that means he's reinventing reality. Okay, so what sets this case apart in my mind are obviously the postmortem from other homicides, or the postmortem injuries, and the court must consider them. I understand how horrific they are, and my condolences to the family and friends. This was horrible, and I know the court has to consider that. My point is that as horrible as though that conduct was, it is one of several factors the court has to consider, not necessarily the controlling one. Albeit, I mean, and admittedly, it's terrible. And I understand the court would have to consider it very seriously. My point is that it's not the only factor. So then, as the court knows, and case law confirms, the court's responsibility is to balance the facts of the case with his character and personality. The state's interpretation of his personality is that he is an egomaniac who lures women into dangerous situations, but that's not what you heard from the people who wrote letters on his behalf. And that is supported by the fact that he had no criminal record up until this tragic event. So in terms of finding the right balance, the court has a very difficult job. I don't envy the court in trying to find what's just and fair in terms of the facts of this case, the ability for Mr. Ferlazzo to safely rejoin society at some point before he's 80 or 90 years old, under extremely strict supervisions, which would continue for the rest of his life, and the period of incarceration. So he has something he wants to read to the court about how this experience has affected him, and that's all I have to say right now, and I would like Mr. Ferlazzo to